Hey everybody, it's Jane Johnston with the Briar Hill Group at Remax Closen, host of Vancouver Island Time. Today I'm here with Sarah Elwood of Sitka Law Group. She's going to be talking to us about cohabitation, co-ownership, different types of ownership, what types of ownership are most advantageous for people. So welcome, Sarah.
Thank you, Jane, for having me.
No problem. It's a pleasure. So you've been very helpful to me in real estate for a long time. And I'm just wondering, first of all, when people buy a home as a couple, what's a general type of ownership that they have?
Sure. Yeah, that's a great place to start off. So one thing I do want to just sidestep back to quickly is that this is just legal information. This, I have to do this part, that this is not legal advice. One thing, especially when we're talking about this topic, that everyone's situation is so unique. So the kind of documentation and the kind of ownership we're going to talk about today is just, it can vary so widely. So I may be doing some general overview, but there's a lot in the particulars that makes a huge difference. So, even when we're asking for a couple, typically you would see someone in a marriage or a marriage-like relationship, they would own property jointly. And so they're called joint tenants.
Right.
And some of these terms we use they go way back. I mean, we borrow our land title system from the Old English Torrens system, and the joint tenant notion started there. What we mean by a joint tenant is that you jointly own the whole of the property. Mm-hmm. And my favorite metaphor, I'm not sure if anyone's told you this before, but it's when you think about a pie. So if you think about the whole of the property as one pie, whatever flavor, your choice, you jointly own the whole of the pie. So it's not, my half of the pie and my partner's half of the pie. It is the whole thing. So if, unfortunately, if my partner passes away, I get the whole pie.
Right.
This is not, if my partner ever goes missing, I did not steal the pie. So that's the situation here we're looking at. And the thought behind it as well is when someone is in a marriage-like relationship, usually you're intending that your assets are your joint assets, and that both people bring something to that relationship. So the same thing goes for property. And the benefit of a joint tenancy is that if someone passes away, the other one can actually just apply to the land title office with the copy of the death certificate and become the sole owner. So you actually don't have to have that asset go through the process of probate, which does inevitably end up saving you some costs there as well.
And so this is a discussion I think people need to have with their lawyer before they actually meet the lawyer on the day of, because you'll draw up the papers for the land title office with that in mind, right? So that's one of the questions you're going to ask.
Yeah, what we try to do in our office as well is reach out as soon as we can, when we've got all of the instructions, either the contract from you in your office and any associated documents there, as well as the mortgage instructions. With that, we sort of reach out and say, here's some questions we have just to get things started, because the contract has a lot of information, but usually doesn't have their social insurance number, all these little details that we need to confirm. And we usually send out like a quick blurb, just explaining what this is and inviting the client, if they need more explanation, if it doesn't quite make sense, we're happy to have that conversation. And sometimes it ends up being something that changes. And if you're sitting in my office and just we for some reason didn't have the right thing on there, we'll change it. We can make changes. It's not, unfortunately it's in writing, but it's not set in stone. So if we have to switch that over, we can, but earlier is better.
Right. Yeah, because it's stressful anyway, right? Getting in there and signing the documentation and all that stuff. What about the other
right now? Yeah.
So let's say two people buy a home and one wants to live upstairs and one wants to live downstairs. I find this often happens with families. And I always say to the client, you really need to discuss how you're going to get out of this ownership as well. So not only getting into it, it's very easy to get in, it's always harder to get out. So for instance, if you're buying with your parents, what type of ownership would you recommend there, or a friend?
So this is where there's a few nuances. So again, when you're saying parents, sometimes people do want to be joint tenants with their parents. And that's where we go into the age of everybody involved. Sometimes parents wants to put their children on, their children are 15. No, absolutely not something that we recommend. For one, a 15-year-old can't enter into a mortgage, so you're a bit limited there. But sometimes that does make sense. So we sort of look at the situation there. When we're talking in general, though, what situation you're thinking of, we call that tenants in common. And so
Right.
between joint tenants and tenants in common, those are the two terms that we use when we're registering what we call freehold transfer. So a tenant in common, the difference there's a couple. So one is that you don't have to be 50-50. You could be 99 and 1, you could be 37.5, you could be whatever number you come up with within the realm of reasonableness. I think it's five decimal points. So you have to be very confirming with that, but you can split that in any way that makes sense. And the other part is that unlike the whole pie and unlike the joint tenant situation, if you pass away and you own, say you and I own, if you pass away, presumably you don't want me to inherit your half. You have a family, you have children, you would like that to go to them. And so this allows for you to have direct for that piece of property, for your half to go in accordance with your will, rather than just purely through the right of survivorship.
Right. So if you and a friend bought and you passed away and you said in your will that it was to go to your children,
Mhm.
then it would go to your children after
That's
probate.
Yes. And again, you do go through the process of probate. When we're talking about children, it depends again on their age. A lot of times minor children will be held in trust. So that would be as a trustee for them. But exactly, you can decide who you want that to go to.
Okay. So what about taking that to a business relationship in purchasing buildings?
Yeah. So when I'm thinking about a business relationship, there are a couple situations. And I think rather than dividing it by the nature of the relationship, it makes sense to do it by what vehicle you're using. And the two main ways that one could potentially go into business, either as an investment property or that situation you contemplated with, it's a business relationship to have you own upstairs and someone else own downstairs.
Right.
We would look at personally or through a corporation. And when we're using personally, we're using tenants in common. One, it could be even, if you've got the upstairs downstairs situation, 50-50 is completely permitted. That is very common. We have had people who have wanted to enter into that kind of an arrangement due to cost, due to, the best home you can get for the amount of money you're able to put in. And so then, when you're looking at holding things personally, that's where we start to look at other legal mechanisms in order to help govern that relationship. And I think that's what you alluded to at the beginning of this conversation as well.
Right, because you have to decide, okay, so if you're a child and you're entering into a purchase with your parents and all of a sudden you bring a spouse in, you have to decide, okay, well, what is the contingency if somebody brings a spouse in? Do they, are they going to become part owners or not, right?
Mm-hmm.
And they would
Exactly.
like to have a cohabitation agreement, I'm thinking, too.
Yes, and when you're talking, whenever you're talking spouses, and that's where sort of what I said at the beginning here, there's so many nuances to this kind of a conversation. People could be in what we call now a cohabitation agreement. It used to be called a prenuptial. A lot of people still refer to it that way because that's
Right.
how they say it on TV. That sort of provides the direction as to what happens in the case of marriage breakdown with assets. So you actually could have one of those in play and also have a cohabitation agreement a co-ownership agreement in play for specific property. And again, when you're talking about, I do have families who have decided that it's best to protect their interests to have a co-ownership agreement. Now you've got cohab stuck in my head.
Sorry.
No, so a co-ownership agreement is another document that's supposed to govern rights, responsibilities, and then the what ifs. And the advantage of speaking to someone about a co-ownership agreement is that you start to learn all of the things you're not expecting.
The bad
have
side effects.
Yeah, in at the beginning of the relationship, it's exciting. We're going to buy this property. I'm going to live upstairs. You're going to live downstairs. Well, it turns out I tap dance every Tuesday at 2 a.m. and you don't like that. So there's all those sorts of things that can show up during the course of that relationship, and it's really good to try to cover that off at the beginning. And that document can include all sorts of things from the very day-to-day, like how do we portion property taxes? It's 50-50, but what if upstairs is a lot bigger than downstairs? Should that be split that way? what to do if one person's not actually making payments on the mortgage, into the things where we don't know if they're going to happen. Like maybe one party wants to buy out the other one at one point because now they have the cash and they want to own the whole home. Maybe they want to sell to a third party. What do you do if one party wants to sell and one party doesn't? So all those things get dealt with. Same thing with just a note about death, talking about the fact that there is a will and this is going to go in accordance with that, allowing for an executor or an heir to step into the role of that individual in the agreement, which is usually necessary to ensure the longevity of that agreement. And a lot of times I'll talk about what happens if we don't agree. And the nice thing about covering that off at the beginning is that no one escalates it from the go. Usually we go through the course of mediation, something that's a little bit lower, more cost affordable, and can usually get things done.
And also, when you deal with it before you get into trouble, you'll probably be dealing it with cool heads, right? I was going to say
Exactly.
a sound mind, but cool heads, and cool heads prevail. So what happens when a spouse moves in with somebody else? Let's just say it's just a single person and somebody moves in as a boyfriend. When do they transition from being just a roommate to now a partner that might have some rights?
Right. So when we're talking about family law, my understanding is it's 2 years living together continuously in a marriage-like relationship. Family law is not my area of practice on purpose, but those sorts of general timelines you usually stick out in your head because you need to be mindful of that. So that's the general rule of thumb there that we go to. But at any point in that time, if you decide, I have had people who are in the marriage-like relationship, but want to cover off just this one property. So they only want to talk about this property. If one partner already owns it, the other one's like, I'm going to buy in or I'm going to go on the mortgage. You can deal with just that if you'd like. In general, if those sorts of arrangements are being made and you're not planning to go on as joint tenants and there's still some thoughts there about protecting maybe inequitable assets, you might want to be looking at getting a cohabitation agreement in place as well.
Okay. So what about using corporations as an ownership strategy or even a tax strategy?
Yeah, and you hit it right there. One of the reasons that you would look at having a corporation is for taxes. So usually if clients are thinking about buying a property in that way, they get accounting advice very early on. One of the things that I did, I had some sort of pearls that I had written down here. One of them was to decide early. If you are looking to purchase, decide ahead of time if you want to be purchasing in a corporation or purchasing personally. And the reason for that is twofold. So one is assignment. And you and I run into this a lot of times in the new construction side of things. Some people won't let you switch. So
Right.
if you decide to purchase personally and then go get accounting advice and realize, no, a corporation is really in our best interest, it might not be possible to switch that. And the issue is that if you switch from personal to a corporation, you can trigger property transfer tax. And more often than not, you have to pay for that transfer, even though it's all essentially the same person. So that's something to think about early on. And when we're holding...
After title is registered and then they move from personal to corporation, they would then have to, that would be, because it would technically be a sale.
Exactly. It's a transfer and the transfer is registered in the land title office. So you hit that trigger right there.
Yeah.
So definitely something to be mindful of upfront. And then, similarly, when we're talking about upfront, with a corporation, you have some options there. You can decide whether you want to have equal shares issued, if you want to have different amounts of shares issued. And those can change behind the scenes as well. You can change your allotment of shares over time. The other document that we recommend when purchasing in a corporate structure is to have a shareholder agreement.
Right. So
very similar topics to a co-ownership agreement, but it's because you're shareholders of a corporation that owns the property. In that, you can go into even more detail. A shareholder agreement can be much more complex because the corporation can do other things. It doesn't just have to hold property, as long as the articles of the incorporation are aligned with that.
Okay, so I have a question from Danielle here. What if I own my house 50-50 with my sister, but she lives elsewhere with her common law partner? So this is something that Danielle and her sister had prior to her sister moving with their common law partner. Does he have claim of part of our house if they break up? It's a good question, Danielle.
It is a good question. So and again, there's a lot of layers to that one because, I can speak to a little bit to the jurisdiction of British Columbia with respect to family law, but if they live in a different country, even a different province, that's a totally different piece of legislation. But when we're talking about that, again, it does depend a lot on the triggers, and there are certain provisions of the Family Law Act that do go into that. So it has to do with, was this an asset at the time? Generally speaking, my understanding is there could be some right to the increase in the value on her portion only. But again, that depends on the circumstances. So we'd have to analyze the timeline in which they were together, the timeline that lines up with when the property was owned, and add, just to complicate it even further, the jurisdictional matters.
Right. But probably a good idea is just to write the agreement. Get a lawyer.
That is always the most straightforward answer. And unfortunately, a lot of people do look at things like co-ownership agreements as, oh, well, that's just, a cost that's unnecessary. Maybe a lot of the things that specifically a solicitor can help you with are designed to help prevent uncertainty and conflict down the line. So it's sort of an upfront investment, and we don't know, and you can never say exactly how much it could save you in the future, but it could be a huge headache down the line.
Okay. So actually that sort of brings to mind something that I touched on before. So if somebody is a US buyer, let's say they're doing tenants in common, so it's a percentage ownership, and there is the speculation tax of 20% here if you're a non-Canadian resident or you don't have a permanent residence card. So what's the deal there?
So with regards to the property transfer tax, the additional, so the additional property transfer tax is on any interest that they own. And that is a situation where the Land Title Office, not a lot of people see this because it's actually on the form itself, but they do ask about the citizenship of directors of corporations as well. So the shareholders, where are they from? So, there's really no sneaky way to get around that. The Property Transfer Tax Act very cautiously and carefully approaches this subject because they don't want people just to throw the property in the name of a corporation and say, well, the corporation's incorporated in BC, so we're fine. They do carefully analyze where those individuals who have the interest at the end of the day are from. And that is done based on proportion of ownership. But I would be cautious in there as well. We have had actually some continuing legal education seminars on this issue because a lot of times people register 99-1 in order to minimize property transfer tax. And for foreign buyer, that is considered a form of tax evasion. So again, if you are a non-resident looking to purchase property in British Columbia, I cannot urge you strongly enough to get legal advice early because this is one of those things where it could be a potentially, they double the potential property transfer tax as a penalty. So you want to be very careful with this area of law. And again, they've been very deliberate in that legislation. So caution is the best way to approach there.
So you're calling it the property transfer tax, but it's a foreign buyer's tax, really?
So there's a couple layers. There's the property transfer tax. They have the additional 20%,
right,
which is what we were talking about here. There's that speculation and vacancy tax as well. I find a lot of ways to get around that one in the sense that as soon as you rent it for a period of 6 months, I think plus a day, that is dealt with because what they're really trying to avoid there is vacant properties. But the property transfer tax foreign buyer additional 20% is the full way that we describe that one. So yeah, that's the way that we consider that tax.
Okay, so we have about 10 minutes left. I'm just wondering if there's anything else that you want to bring up, anything that's happening in your business regarding real estate law, any issues that are arising these days?
These days it's all about, I think, correcting misinformation. And one of the things that is always a bit of an issue, and I appreciate the business side of wanting to buy and sell real estate without having to actually physically sign any documentation in front of somebody. I know that a lot of clients end up working with their realtors and can DocuSign the contract, they can DocuSign the mortgage agreement, and then they get to us and they're like, why can't I DocuSign the Form A transfer? Why can't I DocuSign the Form B mortgage? And that's, right now we are, again, I'm always going to go back to it's legislation. We have to deal with the Evidence Act. We have to deal with the Land Title Act and the way that those intersect. And even with the COVID-19 pandemic, the Land Title Office acknowledged that there are some issues with that, but there still are witnessing requirements. And what they don't want to do, and what we always want to protect on, is allow for fraud to start to rise. And of course, there's layers of fraud protection at every level. You get to do FinTrack. We get to do Law Society ID verification and verification. It is a bit of a process there, so we need to be very mindful. And they have been very deliberate in not amending the legislation to make it so that we can have this virtual signing. And in part, it's because there is so many ways to trick this. And we want to make sure that we're able to protect clients, because the last thing we want to do is have a rise in bona fide purchasers who are buying property that doesn't actually belong to the person who's purporting to sell it.
Yeah. One of the notary publics, I know what she's been doing is she gets them to sign in the parking lot.
There are so many creative solutions that are out there.
You're physically distanced away from the car, but also it's the airflow. So the chances of getting contaminated are very low. But
yeah, and I had a lovely client, and fortunately for her, our ID on file was up to date, so I didn't have to go through that process again. But we ended up signing outside her house just to be safe, and on the back of a truck. And it was just the best way to go. I'm like, I don't want her to have to come into the office, even though our office is very clean. We've got bleach, we've got gloves, we've got the mask, we've got everything that you could need to make sure that you're protected. But for anyone who's in a high risk category, we, as well as I'm sure countless others, are looking at other opportunities that are available. And I know different offices are taking different approaches, and that everyone's reading this in a different way, and it all comes down to comfort level. But this is the most efficient way that we've managed to work this out.
Actually, interesting thought. I'm showing a property later today, and I'm finding the COVID-19 forms differ from place to place, with what they require. I'm finding that a bit weird. I guess I'm just thinking there should be some standard. Should there not?
Is this forms from the brokerages?
Yeah.
Yeah. I mean, they've probably all gotten separate advice from separate locations for that. It's so hard because this is a constantly changing landscape. It seems like just yesterday that I started working from my living room, but you never know how things are going to end up. And obviously right now we're in that period where we're trying to see if there can be some degree of normalcy opened up. And again, a law firm was deemed an essential business. So we've been operating to make sure that our clients are able to be met with and make sure that their business continues to flow as needed, because we're not going to just drop everybody's sales and purchases off the map here. But it is important to learn how to adapt and overcome at this point in time. And we don't know what it's going to look like moving forward.
Yeah, well, I think it's going to change. I think we are in the new normal. We're certainly close to it. I know in real estate, most of everything is done virtually, and the viewings, when they happen, are very warm viewing because people have already previewed the video. You're right, though. I do worry about fraud with buyers and sellers, and we have to be careful as realtors when we're meeting people to verify their ID. So it's all done, as well as we can. And I think the innovation is, I wonder actually for open houses if they're going to be changed now to be totally virtual, because they make sense. So we'll see about that. Okay, well, thank you so much for joining us. And if you guys have any other questions regarding law, Sarah would be glad to answer. Sarah is with Sitka Law Group, and you can reach her at 778-265-2677 or sitkalaw.ca. And where are you located? On Shelbourne?
We're at the intersection of Shelbourne and Cedar Hill Crossroad, just above the Coast Capitol in the corner there.
Awesome. Okay, thanks for coming. Tomorrow we're going to be talking with a lady with the from Bodacious Boutique. She's going to be talking about how she pivoted her business to do very successful sales during a time when probably a lot of people aren't showing or buying homes. And then on Friday, we're going to be talking to a lady who's singing to young children over the internet and engaging them that way. All right, thanks, Sarah. Really appreciate having you here. And hold on, we have one comment. A thumbs up from Lori Frank. So thank you very much.
Thank you, Jane, and thank you, Lori.
You're welcome. Take care. Have a great day, everybody.